Good morning, everyone. Thanks for coming to our panel here at the 44th ABPI Congress. We're very happy to be here. My name is Fernanda Cohen. I work at Betting Advogados, and I specialize in litigation with a focus on IP and tech. And I'm fortunate to be joined here today by two outstanding colleagues. From Geneva, Switzerland, we have Laura Locks, who is a legal counselor in technical barriers to trade and focuses on standards and regulations at the Trade and Environmental Division of the World Trade Organization. He has a master's in both international relations and intellectual property. So thanks so much for coming, Laura. We're very excited to listen to your speech. And from Amsterdam, Netherlands, we have Bart Arsiecki, who has a PhD and is a partner at Van Dijpen van der Kroft Advocaten, where he's the head of the IP and IT departments and specializes in the fields of intellectual property, IT law, tech-related commercial litigations. Bart is admitted to both the Dutch and German bars, and I'm sure he will have a lot to say on the subject today, so we're also very excited to listen to what you have to say, Bart. Thanks for coming. We're lucky to have a very international panel as we're here to discuss artificial intelligence regulation worldwide. A lot of times when people think about artificial intelligence, they go straight to the Matrix. They go straight to 1984, they go straight to Fahrenheit, all of those dystopias that predict that humans will be made expendable or be dominated by robots and machines. Oddly enough, no one ever talks about the Jetsons. I mean, wouldn't it be lovely to arrive home, have Rosie the robot cook your meals, or do your laundry, or clean your house? That would be incredible. And this is exactly what we're here to talk about, because we want to be able to benefit from the many great tools related to AI, but we also want to be able to avoid some of the possible negative externalities from this new and transformative type of technology. One of the ways that we know how to do that regulation. That way we can ensure ethical and fair use of this technology that can help us overcome so many challenges of modern day life. Some of these challenges we are aware of, we can already imagine, and we have been discussing in this Congress. Some of them we don't know yet. We don't know what we don't know. And so how do we regulate? When do we regulate? To which intensity do we regulate? Those are all questions that we are still unsure, but we can be inspired. In Brazil, we are not as advanced as some other countries when it comes to regulating AI. We know that there are a few bills in Congress right now. One of them is more advanced, as you know, powered by Rodrigo Pacheco. But we're still not there yet. Nothing is written in stone. Still, we have the advantage of seeing what everyone else is doing and taking the good experiences and what's working and fixing what's not working and making it more adaptable to our Brazilian reality and the complexities of our society and what we still have to fix in Brazil. Also, we have to take into consideration that this is an evolving type of technology. So this is very important when we're talking about regulating AI. As I said, we do want Rosie the robot, but we do not want to have to call Keanu Reeves to dodge bullets in slow motion. So we will have Lauro and Bart's speeches. We're very excited to listen to what they have to say, what experiences they can bring from the foreign experience. And if you have any questions, in the end, I hope we have some time for them to answer your questions. We'll be around also in the Congress, but we hope that we can take questions from our audience here at Porto de Galinhas, as well as our online audience. So Laura, without further ado, we're really excited to listen to what you have to say about the world regulation, the principiology, about trade especially, which is your specialty and what you're going to focus on. So you have the floor.
So thank you, Fernanda, for your words. And I think you made my job a little bit easier. You raised some of the points I intend to share with you in this few minutes I have. I will try to keep within the time, but I'm not so optimistic. Let's see if I can cover this vast and important topic in the time that has been allocated to me. But also before just proceeding, thank you very much for the ABPI for inviting me to come here. It's a pleasure to be here, and from what I've seen, is a great and successful event already. I learned a lot from this session I attended yesterday, and which I think is also making our job, mine, and Bart and yours, a bit easier because a lot has already been said on different IP AI elements. But what I would like to cover here in this 20 or so minutes I have is to talk with you about specific aspect of this global regulatory governance that is taking shape um, perhaps since 2019, but in particular this year and last year, because countries have already realized, as you mentioned, the need of regulating. I think the issue is not so much the regulation of AI, because regulation can take different shapes, can take different level of stringency, but it's more how you regulate, how wide, how narrow, how cogent, how so, and because of the nature of AI that you already described, the pace of this technology, the different dimensions, regulation can be a challenge. And that's the reason why I think governments and economic operators have realized that AI is a global issue, really needs to be coordinated at the global level as well. So there is this emergence AI global governance process taking shape. And what I want to share with you today is what is the role of the WTO, where I work in Geneva, in this conversation. And let's see if I can succeed in making a few points. But first of all, I think probably this is already a cliche. AI is the new electricity in the sense that AI is a general purpose technology, and Andrew Nye, a known computer scientist, uh, coined, I think, this term, and I think it's very appropriate. Perhaps it's even AI, maybe even more than in other words, AI has this capacity to permeate different technologies, different aspects of a society, products, services, innovation, a general purpose technology. And as such, it has this promise of delivering a lot of benefits to society economies. But I think the other side of the coin, I won't dwell too much on this technical and descriptive part of AI. I think others will do this and have done this better than me. But I think the important point is that, and as you mentioned, Fernanda, and others, precisely because AI is general purpose and can permeate and promise many benefits, the other side of the coin, according to many, is that it can also raise many important risks and challenges. And that's the reason why we see more and more popping up in different jurisdictions, many process of regulating and adopting policies and approaches to address those various risks. As I said, the issue is perhaps a bit more how you do it, and because it can be done in so many different ways, there is a need to deal with that at the global level. What I'm saying that AI is inherently global and in need of global coordination is not from me, but as you will see in a few moments, because I will try to describe what is taking place in the world outside the WTO, because I think the WTO perhaps may be a newcomer in this discussion, but we have several processes going on at the OECD and other places dealing with this issue, try to coordinate AI governance. And in one of them, the Bletchley Summit, you probably have, some of you have already seen last year, a summit that was convened in the UK in Bletchley Park. If you've seen the movie Imitation Game, it took place in that venue, that important episode in the Second World War. That declaration, which Brazil and China and EU signed, in the very beginning of the declaration, they mentioned that AI is an inherently global issue in need of global coordination. But of course, what will effectively go on internally will take place in governments, of course, and internally. in domestic regulations in jurisdiction. So the issue is that I try to address a little bit here is that in that conversation of global governments, what is the role of the WTO? So I think it's important to understand why trade perhaps is important here, trade as an economic phenomena, but also the WTO disciplines, trade disciplines. To what extent they can also contribute to ensure that when members, governments, we call members in the WTO, adopt regulations, standards, and policies on AI, how WTO processes and disciplines can help members ensure that those interventions can both harness AI benefits, because I think it's important to highlight here that regulation can also be to promote and harness benefits. It's not only to address challenges. So there are various different processes and disciplines in the WTO that perhaps can, when members adopt this type of regulation, they can ensure or help ensure that those regulations both harness AI's benefits and also fulfill as much as possible the need to mitigate AI's risks. But why? I mean, is AI a technology like any other? Why members or experts are and governments at these global governance discussions? What makes AI a particularly challenging topic for regulation? And things I'm going to mention here have already been mentioned by others. I mean, I think we had this presentation yesterday afternoon on marketing and AI, which highlighted this aspect of, well, the opacity. But before that, I would just mention one special characteristic is the fact that because AI is a general purpose technology, it permeates so many different domains and sectors. And when this becomes a subject of regulation, this is a challenge. The very fact that it be applied in different domains, which is general purpose, is multidisciplinary, can be a challenge for regulation. But the second aspect is the opacity. And that was already mentioned yesterday in that presentation in the afternoon, that sometimes if you want to regulate something, you want to understand why a certain action was taken that resulted in some harm. But as was mentioned yesterday, AI has this so-called black box problem, which many times is difficult to understand from the algorithm why it took that decision, why it made that recommendation, why it made that prediction. And that has created some difficulties in terms of asserting responsibility, ensuring accountability, liability, the transparency issue, which is very important in regulation. And the other thing, I think you mentioned that, is the so-called pacing problem. I think the speed of the evolution of this technology is mind-boggling. It seems like it was a century ago that ChatGPT 3.5 was released, but I think was just 2 years ago. Every week, almost it feels we have a new AI product being deployed. And then also, I don't know about you, I'm not an AI expert, I'm a lawyer, but even to keep up with all the terminology, it's very, very difficult. I keep reading 10 times. Sometimes I even ask ChatGPT to help me understand. And so, I think it's a challenge in the terms of the pacing problem, in the sense that it's a cat and mouse game in which regulators try to come up with a regulatory framework, but next day the technology evolves and then is no longer sufficient. So there is this particular need to ensure that AI regulation is future-proof, that is fit for purpose. And that, I think, is another challenge, in particular for developing countries. Now, but one important aspect, I think, and I think it's an aspect that is particularly relevant for trade, is regulatory fragmentation. And I think, Fernanda, you mentioned that AI engenders not only traditional risks. You have AI as an intangible, an algorithm, but also we have more and more AI embedded in services. But I think there is a trend now in the future for AI to be powering products, physical products, Internet of Things. And one characteristic of AI, I think, that it may engender not only the traditional risks that are regulated, safety, quality, environment. If you have a autonomous vehicle, for example, that you want to regulate, is not only targeting the traditional aspects of safety and quality innovations that you would have in a non-AI powered product. On the top of it, you may have also the other immaterial risks considerations like privacy, fundamental rights, human rights, ethics, morality, etc. That adds an additional layer of complexity to regulate these products. How, and that's the reason why I mentioned this element here of social technical. So regulating AI is becoming not only a question of technical regulations or technical standards, but social technical. But that is a nice word, but how you do it in practice may be complex. And because when you're dealing with fundamental issues and societal issues like culture, societal values, and privacy, this privacy for you may not be for me. And that's the reason why I put this under this element of regulatory fragmentation, which potentially means AI may be regulation may be particularly prone for regulatory fragmentation because one country may regulate in one way, another country in another way, justifiably so perhaps, but may perhaps circumstances. And why this is a trade issue? Because if you have a medium-sized, small, medium-sized enterprise, and you are exporting AI products or delivering, supplying services to 10 other countries, if the 10 countries have 10 different regulations dealing with the same topic, that may represent a big compliance cost and a trade barrier in and of itself. It's not only a question to comply, but also to certify. So certification of AI regulations perhaps has the potential to be quite significant. And that's the reason why, and I will try to move fast here, but I want to show why the WTO some disciplines may be important, because the role of international standards as a basis of regulation and domestic and national standards can be particularly useful here in order to ensure that at least there is some minimum common basis for regulation across jurisdictions to deal with this regulatory fragmentation. But before I just move to the WTO as perhaps an important future or important element or player in this global AI governance, I want to have time to in detail describe all these processes. But I think it's important to note here that this global governance discussion is not starting now. It has started with the OECD in 2009, issuing the very first international principles on AI with high-level principles in terms of human-centric and ethical concerns when you're regulating and doing policy on AI. I won't have time to describe all the principles of all these processes, but on the OECD, I just wanted to stress that they have a definition of AI systems. Many of you deal with regulation here, and one difficulty sometimes is that understanding what is being regulated. So terminology and defining what is the subject matter of a regulation is the starting point. If this is ambiguous, or if each country define what is AI system in different ways, again, you have fragmentation in all the problems I just explained. So these OECD principles, they came up with an international definition. And what we are seeing more and more now, and Bart, I think you were going to talk about the AI Act from the EU, we see some countries already adopting the same definition, which I think it's an interesting and useful development because it may ensure less fragmentation. Also, the G20, we're going to have the G20 in Rio in November, but in 2019, they also had the AI principles, but rather they reinvented the wheel. They adopted the OECD principles. Very quickly, just the framework, this framework convention on AI, human rights, and democracy and the rule of law was just adopted this year by the Council of Europe. It's a regional body, but actually this is the first hard law convention on AI. So it has also various disciplines that are dealing with regulation as well. They mention IP, but it's open to all countries. So this is an important development. I have all the descriptions here, but I just want to highlight one thing. I mean, the previous ones are on UNESCO, G7, the UN is also have a UN advisory body, which is also producing important principles and guidance. Oh, sorry. But I want to end here, not mentioning much what's taking place in the General Assembly in the WIPO, but the AI summit that I just mentioned. One important development that I would actually suggest, if you have the curiosity to read, is that they have issued, also coming from this summit in the Bletchley Park in November, they have requested the issuance of a scientific report. You know the IPCC over climate change. They had this very good idea to separate policy from science. So the IPCC kind of compiles at a meta level all the best science on climate change, but only a description of the state of the science, and they leave the policy to government. They don't mix the two. And the same idea was done with the AI here. And the report was just issued. They describe the best science on AI risks in different dimensions, and they have a chapter on intellectual property as well. So, and one of the issues they mentioned is watermarking, that was also mentioned yesterday in afternoon in that presentation. Now, so what is the role of the WTO? You keep me on my time. What I want to say in terms of the WTO contribution here, potential contribution, of course, you have the IP element. You all know the TRIPS agreement on trade-related aspects of intellectual property rights. But because AI, it's a digital issue, it's coming in the context of digital trade, which is increasing more and more, trade on digital-related services, products, and intellectual property. At the same time, it's not exactly is not coming to the WTO in isolation. So there's a whole tradition already in the WTO of dealing with these broader digital topics. And in different WTO, this is not an exhaustive picture, but I will concentrate the remainder of my presentation on the agreement I work more closely. Another mentioned the agreement on technical barriers to trade, which is about domestic regulation and standards. But I just want to mention one aspect here, or two aspects. One is the trade facilitation agreement and why that may link to AI and intellectual property. Because this is the last WTO multilateral agreement dealing with customs. Gabriel mentioned yesterday the port of Suape here. What this agreement does is to try to cut red tape to avoid that customs procedures do not become too burdensome and complex. But one aspect this agreement also promotes is the use of technology to make customs more efficient. And there is also the discussion now on how AI can help in particular customs officials to check if imported products are counterfeited or falsified. So there is this interesting connection between trade, IP, AI, and customs procedures. And the information technology agreement also is important. I would just want to mention one thing which I think is important is the fact that, yes, we have AI as a transformative technology, and trade can facilitate flow of this technology. But there is the broader level, there is the whole infrastructure that makes AI revolution possible, which consists of other technologies like advanced microchips, microprocessors, and telecommunication infrastructures, computers. All of this is needed. If you don't have that, you won't have AI. So that agreement, it's about zeroing tariffs and eliminating other barriers of this type of products. So it's important to see the role of trade from that perspective as well. But just moving quickly to my agreement, because I think that's the main point I want to make here, is that this agreement is basically about regulation. And members take regulation domestically to address policy issues, health, environment, safety. And the WTO agreement on technical barriers to trade does not really affect the sovereign rights of members to regulate. What is concerning is how to do it. That's the reason why in the outset of my presentation, I mentioned the issue is much more how you do it, not whether you should regulate. It may be that certain moments you don't need any regulation, but I think in terms of trade, the question is much more how you do it. So if you do it in a way that is not based on science, there is no evidence, it's disproportional, it is discriminatory. So the agreement on technical barriers to trade try to, through its various disciplines here, try to filter out regulatory interventions that are trade restrictive because they are unnecessarily so. Maybe rather than making a regulation mandatory, you can just do a voluntary standard. Or perhaps rather than saying how a product should be produced, you can just use labeling requirements. So it has various disciplines, but I would like to just stress harmonization and transparency, which are particularly important for AI governance. And why? Well, harmonization, I don't need to explain much more because I already mentioned the benefit of harmonization as a way to prevent fragmentation. If you have an international standard, international standards are not done in the WTO, are technical documents that address technical or problems, the optimal solution for a problem by a technical body. For example, the ISO, ASTM, all the international standardizing bodies, IEC, the ITU, the International Telecommunication Union. So the WTO agreement promotes domestic regulation to be based on that, because with the idea that if you have an AI regulatory issue and there is an international standard on that, if all 10 countries that I export base their regulation on the same basis, same standard, you have less fragmentation, and it's good for trade, but also I think good for society in general, because those documents are done by the experts as the best formula, recipe to address an issue. And transparency, why I mentioned transparency, I just try to move on quickly here, and it links to my almost final points on the role of the TBT committee, the committee that administers the TBT agreement, which is not just a bunch of bureaucrats going there. It's a very special committee because it's a place where members come and they raise actually practical problems with regulations that are taking place right now or being proposed right now, and they discuss very openly, frankly, in a non-litigious way, these problems, and many times, rather than starting WTO disputes that are important but can take many years and can be costly. What we have in the TBT committee, I think I would submit that can be particularly relevant for AI regulatory global discussions, is this practice. Because, I mean, one of the issues I mentioned, the pacing problem. These technologies are evolving very fast. You cannot wait 3 years, 10 years for a dispute in the WTO to take place to understand if the measure, the regulation is okay or not. In the committee, you very informally, but also with substance, you raise concern, one member against the other, or with respect to the other member's measure, and they discuss of everybody, and many times this problem is solved. But why transparency is important for this process? Because in the agreement, the obligation is to notify measures, regulations that countries want to introduce, rather than one is already fait accompli and the regulation is already adopted. This really facilitates the discussion and also solving this in this formal, informal, and cooperative manner. And we like to show this inverted pyramid here, because if you're talking about domestic regulation standards, it's thousands of regulations. In this very room, everything that is here is probably subject to a standard of regulation in many aspects. So we have almost 55,000 notifications, but actually only 11 disputes dealing with the TBT agreement,
Existem 11
precisely
litígios no
because you
âmbito
have all
TBT,
these
exatamente
other
porque você tem
mechanisms to
todos
deal with
esses outros
friction
mecanismos para
in a
lidar
more
com
expedite and
esse tipo de
friendly and
problema de
cooperative manner.
forma expedita e cooperativa.
Don't worry, it's a lot of
Não se
information here. I
preocupe, é
just
muitas
want to say that
informações. Eu gostaria apenas de dizer
in the
que,
context of this
no contexto
specific trade
desta
concerns, this committee discussions and
este
notifications,
comitê, as
digital
discussões e
issues are
notificações,
already
questões
taking place,
digitais
at least in the
já
last
estão
10,
ocorrendo
5
pelo
years,
menos nos
in
últimos
many
5
areas,
ou 10
including
anos
more
em muitas
recently
áreas,
AI.
incluindo
But we have
recentemente a IA.
many
Mas nós
discussions
temos
on
muitos
regulations on
debates em
5G,
regulamentações de
drones,
5G
autonomous vehicles,
e
cybersecurity, all areas that
segurança
are not AI
cibernética,
regulation itself,
que não
but
são
they relate to AI. And so we have practiced already a 5-10 year tradition on discussing all these regulations, and more recently on artificial intelligence. So in 2021, the EU notified its draft AI Act, and just a few weeks ago, Kenya is the second country to notify a proposal to its AI regulation. What is important is transparency. Economic operators, companies, civil society, when this is notified multilaterally, already know this immediately. They can raise a concern. China indeed raised a concern in the TBT committee again with respect of the EU AI Act. They were concerned, for example, with the definition of AI system. The issue I mentioned, they said that was a little bit ambiguous. It was too broad. Then the regulation would, they didn't know what will be affected or not. And indeed, the EU, I don't know if it was necessarily because of this, but in any case, the adopted AI Act, actually, the definition that is there is different from the initial one, and they kind of adopted, but you can correct me if I'm wrong, the OECD definition instead. And I will end with that. I have some concluding remarks, but perhaps I can, if I have time, I don't know, it's up to you. But I just want to say that there is another process in the TBT committee looking forward, is that members already know the importance of discussing these topics. And we have what we call the triennial review, which sets the agenda for the committee for the next 3 years. It will be adopted in November. And you can see from this little sample of topics proposed by UK, Australia, and US, that AI is already there. They want to discuss this as a horizontal debate, exchange of regulatory experiences in these topics. Not only AI, but as you see here, semiconductors as well, because they understand that, as I mentioned, this is part of the broader framework to make the AI infrastructure really happen. So the US, for example, is proposing to discuss international standards in this area because they understand what they call the critical emerging technologies.
O que falam emergentes tecnologias críticas,
they understand the
e eles
important
entendem a importância
international
do papel dos padrões internacionais nos governos. Eu vou pular isso e vou concluir com esse último slide. O que eu mencionei é que a inteligência artificial tem todos esses benefícios transformativos, mas também tem esses riscos que são complexos, porque não são só os riscos de meio ambiente ou de moralidade e ética, e sabemos que existe um risco maior de uma fragmentação regulamentar. Então temos vários acordos na Organização Mundial do Trabalho que pode ser fragmentado e também pode trazer muitos benefícios, mas eu digo que a Organização Mundial do Trabalho tem essa capacidade
taking place, but, and that's my final point, without duplication, because I think there is, even at the international level, a lot of things going on, and I think it's also important that the different processes converse with each other to avoid duplication. but rather and promote complementarity. So probably I exceeded well my time, but I thank you for your attention, and I'm happy to take questions after Bart. Thank you.
Thank you so much, Lauro. That was like a few minutes jam-packed with information for us. It was incredible to listen to all of the initiatives that the WTO is So thank you so much for sharing that with us. I'm sure everyone will have a lot of questions for you in the end. But now we're going to take some time to listen to what Bart has to say. He's going to focus on the European AI Act, which is an inspiration for some of the initiatives that are happening here in Brazil. So it's very important for us to understand what's going on there. And I'm sure Bart will let us know very well. So Bart, please take it away.
Yes, thank you so much. And first of all, I would like to thank you to the organization for giving me this nice opportunity to show the great European Act on AI and to discuss it with you. Maybe some of you are aware of that act. That act was published about 1 month ago. It's the, we call it the AI Act, but actually it's the regulation 2024 and 1609. No, 1689, sorry. So what is this all about? I'm originally from Germany, so the Germans always show nice structure in their presentation. So I will discuss a little bit of a background of the AI Act, an overview of the AI Act, and then I will show you what's not regulated in the AI Act. And then I will draw up a little summary. The thing is that the European Union started in 2018 to work on the AI, on the European AI Act. And I cannot read from so far away, so I have to put my own slides here. So the purpose was that Europe should become a global center of trustworthy AI. So the idea was not only to regulate the AI as such, but to regulate it in such a way that consumers can have can trust in the use of AI. And they wanted to create an ecosystem of trust and trust of mankind in AI. So people had to. The idea was that people, have the trust in using those systems and are not scared. And another point was to create legal certainty. So as you can see, there was an EU AI strategy based in 2018. It was introduced there, and there were a couple of reports. My biggest concern on the AI Act as such is that the ideas that were introduced in 2018, they are the same ideas, the technique developed, but the principles that were introduced in the AI Act are from 2018. So this is kind of a little bit of my biggest criticism with respect to the EU AI Act. And the quite challenging thing for me was right now, because when you look at the AI Act, it has like 144 pages. So it is a really extensive piece of legislation that the EU introduced here. So to put it into 15 minutes, it's quite a challenging factor. So let me show you the main points of the European AI Act. So I think the most interesting thing is the applicability and the definition. As you mentioned that, the definition is actually based on the OECD guiding principles. And the general provision is in Article 1, and it says to improve and promote the uptake of human-centric and trustworthy AI while ensuring a high level of protection of health, safety, fundamental rights. And it is said in Article 1, paragraph 1 of the AI Act. So the fundamental rights in the EU have a very high standard, and also depends in which kind of EU country you are. As you said today, very interesting. What's for me privacy and data protection doesn't have to be for you privacy and data protection. This is all. I know, for instance, that in Germany, data protection plays a really big role. So in the Netherlands, on the other hand, data protection plays a role, but not as extensive as in Germany. So the level that we create in the EU is, on one hand, is a harmonization, but on the other hand, how the whole protection takes place is a different story in the different member states. So, and this is maybe the whole European system that we have here. It is a regulation, so it has direct effect. So it doesn't have to be implemented into national law, but there are certain parts of that regulation that still have to be kind of, I would not say implemented, but they have to be adjusted into the national law. So, and one of the things are, and I come to a little bit later to that, are the regulations on the national authorities, because they introduced a system of national and European authorities. When we look at the definition, it says it's a machine-based system that is designed to operate with varying levels of autonomy, and that may exhibit adaptiveness after deployment, and that for explicit or implicit objective infers from the input it receives how to generate output such as predictions, content recommendations, or decisions that can influence physical or virtual environments. So this Article 3, number 1. What the key issue is that the AI has the capacity to infer, but how the levels of that interference are, and how the levels of just say the varying of the autonomy are, it doesn't say in the AI Act. So the big question that was raised by scholars on this topic is whether normal software also falls under the AI Act. In other words, what level must the output be in order to be applicable under this AI Act? Let me see. The scope of application, it applies to the whole life cycle of AI. So from the beginning on, when you develop it, to put it on the market, and also market observation is another point that falls under the AI Act. And it applies to the providers of the AI, and also to the deployers of the AI, which are defined in the AI Act. And as I said, it has a risk-based approach. So there are levels of different AI systems where it's either forbidden. So those are the forbidden AI. That's mostly AI which is used for personal identification, for discrimination reasons, scrapping, for like violation of human rights. That's the one thing. Then you have high-risk AI systems, which are defined in the annex to the AI Act, and that annex is renewed each year. And there you have monitoring duties, compliance duties, transparency duties, which are put on the providers of the AI, and also on the deployers of the AI. Then you have limited risk and low risk AI systems. And each of the step, the obligation to have transparency rules, to have observation rules, compliance rules, they will be lower and lower. Another interesting point is the generative purpose AI. Those are the ChatGPTs and the co-pilots from Microsoft that we know, and they have a special provision in the AI Act. They are they kind of fall outside of those risk-based application. What does not fall under the AI Act as such, those are the application of AI for state security and for military. Those rules do not fall within the AI Act. They don't have to adjust with it. And there is another provision for open source related AI systems. So they also have a certain, it's accepted from the. As I said before, they introduced a system of EU and national authorities here. So they have to, those authorities, they have to observe the market, and that's where you have to, file your compliance forms of how you observe transparency, how you comply with the whole regulation. And here it's an interesting thing because I don't know how it's in Brazil or in South America, but we suffer from a lack of personnel. So people who can, be in those authorities. So they say, on one hand, you have very strict rules, and on the other hand, it might be that you cannot enforce those rules because of lack of people being there in those authorities. Who will be at the end of the day which authority will have such will be created in the different member states? We don't know yet. And then we come to the sanctions, and I think the sanctions are pretty strong, and they remind me of the system of the GDPR. Where it's based either on a fixed amount or on a percentage on the turnover. So the whole AI regulation is, in my view, a regulation that is kind of it took a lot of things from the Digital Service Act, from the GDPR, from the Digital Market Act, where the sanction system is kind of the same. What's not regulated, those are the IP issues. We have the input issue when, for instance, you feed the artificial intelligence the system, but also the output issue. Who is becoming the owner of the work that is generated by the AI? This is not regulated yet, and I don't know whether they will. They even started to regulate these issues. It will probably fall under the European directive on copyright law, but at that moment it's quite open how the topics will be. Then you have the liability issues, and here a product liability directive was introduced. We had our first product liability directive. I think it was one of the first legal instruments that worked pretty well in '85. So right now they reformed it, and it's as far as I'm concerned, it's pretty much putting the product safety the standards are pretty high. What's also not regulated in the AI are contractual issues. can an AI system be a contract partner? I think that's quite interesting, but it's not regulated in the AI Act. And procedural issues. And here I actually wanted to show you one nice example in the Netherlands. There was last week or 1.5 weeks ago, a district court, a judge used ChatGPT in his judgment and openly said that he looked at the lifetime circle of a solar panels, you know, where you kind of get a solar energy, because there was a twist of two neighbors about the panels. How long do they, you know, what's their life circle? And he said, according to ChatGPT, it is like that and this. So this was the first decision, and it kind of divided the legal you can say the legal world in the Netherlands between those guys who are saying, well, I think it's cool to use it, or it's fine, we go with the time, and otherwise said, well, you should be very careful, that goes way too far. But the Dutch Supreme Court released a couple of years ago some guidelines on how to use Google within the legal, you know, world, within proceedings, and that you have to give the parties, you know, the possibility to react on the decision of the court. And there they said this was kind of the thing that the court made it wrong here. To sum it up, I would just say, and here you have my summary, the AI Act will affect lots of companies, not only domestic EU companies, but also companies that sell their products, their AI products, to the EU. So where the output of the AI is in the EU. And therefore, it's for your clients, if you are a lawyer, it's really important that you are aware of it. The companies should really look at it, whether that the AI will you know, affect them. And the other thing, that the whole compliance system in the based on the AI Act is quite, I would say, quite hard. The AI Act was made actually for companies like Google, like Meta, like Apple. Those are companies that can afford a high range of lawyers, compliance officers worldwide, and they can use those there. However, if you look at smaller companies, startups, scale-ups that don't have that issue of that sources to do that whole compliance, I think that the AI goes a little bit too far. So, and parties will still need to regulate lots of issues like IP issues and other ones within the AI Act. I thank you so much. And
thank you, Bart, for clarifying some of the main points of the European AI Act, and also for pointing for us what's lacking still and where should we go from there. So we'll be taking now questions from our audience and from our friends who are watching us at home. Do you have anyone with a question? Otherwise, we'll just talk amongst ourselves. Okay, so Bart, the risk classification is very important in the AI Act. And how do you think it works, and what does it not work in your risk classification? Because we seem to be leaning towards a different risk classification that includes some like dispatching of ambulances and some public services in itself, which I think you mentioned are not as covered by the EU AI Act. So how do you feel about that? Sorry. Yes.
Oi, 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 oi.
Knowing the EU bureaucracy, it will take a while in order to be put to the annex. So I think they should have created not such a system, but more a system of if put a clear definition and then see whether that falls under it, and not the next step to put it into an annex. So if the Brazilian government wants to introduce something, I would make it more clear like this.
Okay, that's a good tip. And Lauro, you mentioned something very interesting. You said that regulation is not only supposed to deter the challenges that may arise from artificial intelligence, but also promote the positive behavior and what's desirable when it comes to AI companies developing these types of tools. Could you elaborate on that? I thought that was very interesting.
Yeah, because, can you hear me? It's fine. Yeah, I think it's because when we talk about regulation, normally it has this negative connotation of always prohibiting things. But when I mentioned that, I was also thinking about the WTO processes and disciplines more broadly. So, for example, when you have the TRIPS agreement, which is about intellectual property, and you have the issue of promoting innovation through intellectual property, for example, measures in that respect. The WTO also deals with subsidies, for example. Of course, many types of subsidies are not consistent with the rules, but the rules themselves also recognize that when you do subsidies, for example, for research and development, this is totally okay. So I think that, but also you have even in the regulatory side. So, for example, you may have regulations on AI, including that have a particular concern with the impact on small and medium-sized enterprises, how you actually promote the same regulation that may prohibit some behaviors can also include, for example, AI literacy, because I think there is an element of that is being highlighted in some of these studies, that AI literacy, if small companies can really navigate all the intricacies of this technology as a barrier to developed products from them. So you have that angle as well. And my final point, perhaps not exactly on, well, I mean, it's in a more positive vein, is going back to the issue of international standards. Because international standards will play and are playing an important role, not only as a basis of technology, but actually even companies, they want to use international standards to streamline their processes. But the thing is that, in particular with complex technologies like AI, is not only a question to show up in an international standardizing body, the ISO, IEC, etc., and then voice your views. You have to be prepared. You have to understand, you have to make meaningful contribution to that. So your angle is included. So there is also this preoccupation on regulation and laws to promote small and medium-sized companies, developing countries, to better participate in standard setting process in this area. So you wanted to add?
I would just say that I don't want to be too critical of the AI Act, the European one. Of course, that it's always something better to achieve later on, and maybe to wait a little bit. But I totally agree with you that I think what's more important on the AI is that we set up international standards and not so much national, or just say supranational, like the EU legal acts, because the big fear of the EU is right now that because of the AI Act, there will not be and development in the EU of AI technology, because companies will avoid the EU. So, you can regulate something, but if you regulate it not in a proper way, then there is the fear that's over-regulation. And my fear was a little bit that the EU wanted to create, as a first, country, a legal act on AI and be kind of the model of AI instead of waiting a little bit and seeing how that develops.
Can I just add one
Sure.
one point? No, one thing that I think I put in my slides, but I didn't have time to address is the issue of dual use. You mentioned the AI Act has this carve out for military use, right? National security. But precisely another compounding element that may increase fragmentation is the fact that AI is more than perhaps other technologies prone to make products dual use. In other words, the same technology can have a civil and a military use. You can have drones to deliver medication, but also have drones as little autonomous weapon. And I'm not, and I think there is no. I don't want to say that a military use is wrong. It's a use, but also then it brings another dimension because more sensitivities. So this issue of dual use is particularly acute when you're talking about AI regulation, fragmentation. How you deal with that is another important challenge.
Well, that seems to be all the time that we had. Time does fly when you're having fun. So thank you guys so much. Thanks everyone who attended our panel. And we hope to talk to you guys about this throughout the Congress. And thank you guys again for being here.
I just got stuck with the definition.
Yeah, so it's yeah. No, but I've been looking over the years.